somewhere in the sidelines for years, suddenly was on the table and was adopted through an amazingly fast process. It was galloped through Parliament and the European Council, and it was a fact in no time. So sometimes we have to realize that we may be in a situation that's frustrating, but if we have reached a certain level, especially at the level of civil society and at the level of a broad community of stakeholders to equality, if people have negotiated their own understandings of how, in an ideal world, one day, good equality law should look like, then it would be relatively easy once the political opening appears to achieve something. Okay, so as I was saying, I will have to read from there, which, let me just make myself comfortable. Yeah, usually I have this here, but I didn't manage to print, and the laptop has to be somewhere there, so I'll try to use that only. So as I mentioned, equality law has made good progress in the European Union, both at the union level and also within the national jurisdictions of the 27 European Union member states, but also, of course, in South Africa and in Canada, and in some ways in the United States. Maybe also in Australia, but for me, it's terra incognita, Australia. So it's not something that I know well about. I'm only getting hints about things that are strong or weak here, but Australia somehow has not been on our map, at least not on my map. And I hope this will change after my trip here. One example of good equality developments is the United Kingdom, where the organization which I direct is based. Just to clarify, I'm not British myself, and the organization which I direct is an international one. It is based in London, but it has nothing to do with promoting British good practices. It just so happens that Britain is a good example on equality. There are many other good examples on various aspects of equality law. One thing I have to make clear that actually people have asked me even yesterday, okay, if you look at various jurisdictions, which is the best? And I hurry to say that there is no such jurisdiction which is the best. On certain issues, one country is better than other. On other issues, that same country is far behind. So there's not one jurisdiction which one can point at as a good practice overall. So we have to glean good models and good practices from a number of places. But the Equality Act, which is part of the 5th generation of equality monuments, and after 45 years of evolution of legal concepts of equality, is one example of a relatively good and strong result, with many defects which still exist, many weaknesses, but on the whole, it's not a bad thing and can be looked at as a good practice. The purpose of this talk is too ambitious. I will not achieve the purposes of this talk. They should be, if I were to seriously achieve them, for which I would need the day, not 20 or 25 minutes, would be to present. I'll hint at the possibility to present current global trends in promoting equality and to present best practice models and solutions to key problems in developing equality legislation and jurisprudence. The indispensable caveat. There's no such thing, of course, as a transplantation of good models and good practices. The context is everything. The legal system, political context, the needs, the specific real-life needs that emerge from different societies and that require to be reflected and addressed in the law. But all that we want to do is just look at some inspirations, some lessons, and some cautionary tales as well. Major trends recognizing equality law regarding its purpose at the beginning. So now if I'm allowed to take the longer view in a more philosophical sort of way, we can see that equality law regarding how it understands equality itself, equality of what, and what is equality, you can trace the evolution of these purposes, which does not mean to say that you can locate one purpose in one piece of legislation which goes from this year to that year, and then the next piece of legislation. These are just trends. They go, somehow they may overlap across jurisdictions, across pieces of legislation. They're just trends that can be seen as a thread of development, starting from a wish to ensure formal equality in the sense of equal treatment, and not just equal treatment, but in a equal treatment understood in a narrow way as, in fact, identical treatment. The Aristotelian approach of that likes should be treated alike, also known as procedural equality. And this approach is reflected in the UK in the first two generations of equality law in Britain, in the UK Race Relations Act of 65 and of 68. Then the next step is the wish for the law, and the law aims to ensure substantive equality of opportunity. And in the UK that starts to be done in the third generation of legislation, and results from the recognition that formal equal treatment cannot remove the barriers to equal opportunity. There is a good trigger of that thinking at the level of the European Court of Human Rights, which modified its definition of discrimination from less favorable treatment to a definition which includes the need to do positive action in order to achieve substantive equality. And that was in Limenos versus Greece for the first time. The case is about electing women councillors in Greece, and the court said that in order to achieve equality for women, the electoral system had to not operate on the basis of identical treatment, but in fact provide for reinforced women's lists to achieve equal results. And also in this, at this level of equality law is the Equal Pay Act in the UK of 1970, the Sex Discrimination Act of 75, the Race Relations Act of 76, and so on. What the legal concepts through which substantive equality kicks in is primarily, not only, but primarily the concept of indirect discrimination and the possibility for positive action. So in the previous generations of equality law, that would not, positive action would have constituted discrimination, and now it's allowed. And also the concept of indirect discrimination, probably one of the most interesting, some people say difficult concepts of equality law, is indispensable if we are to address systemic inequalities. Next step or stage in the purpose is to ensure comprehensiveness in equality. So previous generations, that concerns the grounds, were focusing mainly in race, sex, and then one by one other grounds were added, Europe-wide, but also looking at Canada, the United States, and other jurisdictions, India, of course, other grounds. And here in the fourth generation, what is essential is the idea that there is no hierarchy between the grounds of equality. That effectively, whether I'm discriminated as a woman or as a disabled person, will not make any difference in terms of my suffering and in terms of my assault on my dignity. So therefore, whatever the ground, there has to be some sort of consistency across the protected grounds and the prohibited grounds of discrimination and protected characteristics, because otherwise there's no